That's where I paid.
Well, that's just-
Paying all this high tech.
Only place I could plug it, well, I could put it over there.
No, I'm kidding.
Oh, yeah.
One minute. You got it? Hmm? I got my speech. So excited about it. Everybody here that's supposed to be on there. Your name's Jim King, right?
Yes.
I'll probably say that. Rick.
Your name's Jennifer, it's not Holly.
It's who?
This is Jennifer, it's not Holly.
Okay. Jennifer Aniston?
Yeah.
Okay.
What's your last name, is? Jennifer Aniston?
I just want to make sure I get it right.
You'll probably mess it up now for sure.
I surely will, because y'all messing with me. Y'all mean, I'm looking at the clock.
That first time you was out here, Rob done me that way, and had me something on closing.
Good evening. This is the September 9th, 2019 meeting of the Union County Board of Adjustment. We are now open and in session. My name is Darren Green. I'm the chairman of the board. To my, I think this is left, right?
Yep.
To my left is Vice Chairman Mark Tilley, our board attorney Bill Sturgis. To my right is Mr. Rick Davis, board member, and Ms. Jennifer Stewart, board member. We also have with us Jim King, who is the zoning administrator, and Pam Rivers, who is our clerk. Board of Adjustment's responsibility is to hear three different types of cases. Tonight we will hear only application for variances, so I won't get into the other ones, but in any case, the order in which case the cases will be is follows. All parties who plan to give testimony, pro or con, must complete a form. It used to be green, I don't know if it is anymore, but whatever color it is, it's up there, and you need to complete that form if you're going to speak tonight, and you will be sworn in. A zoning staff member, who will be Mr. King, will give a quick, brief introduction to the case. The board may question him at that time if they like to. The applicant may also question him if they feel necessary, or their attorney. The board may then question the applicant. Any cross-examination, if there's anyone here in opposition, they may cross-examine, and then anyone who's here in opposition to the case may also then give evidence in the case. You must give sworn testimony. We only hear evidence on our board, so if it's not sworn testimony, it's considered hearsay in most cases, and therefore will not be admissible. After making a decision tonight, we'll close the hearing, and then we'll make a decision as a board. It could take up to 30 days to make a decision. Generally, it does not. You may remain here while we deliberate, but no more evidence will be taken after the hearing is closed. All exhibits that are presented will be kept by our staff, and if your case is not appealed to Superior Court, after 30 days you may pick them up, or they will be destroyed. If you feel there's a conflict of interest with any board member or association that would prejudice the case, please let it be known at the start of the case. We are a quasi-judicial board and can, again, only accept sworn testimony. No hearsay evidence is admissible. Appeal of our decision is to the Union County Superior Court. You have 30 days from the date of the board's written decision in which to make that appeal. Please turn off cell phones. And that's all I have to say about that. At this time, I will look at our agenda. Confirmation of a quorum. We do have 4 board members, which does constitute a quorum. So I'll move on to item number 3, variance petition number 2019-01, 8701 Man of War Drive. This is a variance seeking relief of a 2.6 foot from required 15 foot side yard setback. This time I would call Mr. King to come forward.
Darren,
Yes, sir.
did you want to ask him about form or just like?
Yeah, I can do that if you'd like to. Before I swear Mr. King in, I'd ask the council for on these cases. If you'd come forward, please, sir.
Yes, sir.
As there are only 4 of us here, it is a simple majority to receive approval, but that's 3 out of 4. If there were 5 of us here, it'd be 3 out of 5. So we do offer the opportunity if the applicant would like to, applicants in this case, would like to continue the case to our next meeting. That's a decision that you can make at this time.
At this time, we're ready to proceed.
Okay. Mr. King, you swear the evidence you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. And I guess with this matter, it's complete. So I'll have a motion to hear the case, first case.
Make a motion to hear the case.
Is there a second?
A second.
Okay, we have a motion from Mr. Davis, a second from Ms. Stewart. All in favor, say aye. Aye. Any opposed? Okay, Mr. King.
All righty. Well, the property is located at 8701 Manowar Drive. It's owned by Vitella and Lucy Derkachev. I know I messed that up, but
I probably will too.
they're both the owner and the applicant in this case. As you had stated earlier, they are asking for a variance to Table 5.2 Lot and Building Regulations. The applicant is seeking relief of 2.6 feet from the required 15-foot side yard setback. This right here is the survey of Lot 167. This is where they found out that there is encroachment. If you look at the survey, the encroachment's to the far rear of the building. This survey was taken July 10th, 2019 as part of a closing on the property. Here's the original plat, which is dated 12/19/2000. Things I'd like to point out here is lot 167, the rear property line for the final plat, upon final plat approval, was 78.36 feet. The adjacent lot, which is lot 166, which is to the north of it, had a rear property line of 106.39 feet. To give you the setbacks, this is coming off the original final plat. It's got a front setback of 40, a rear setback of 50, a side of 15, and if it were, in this case, a corner lot, that corner side on Crow Road would be a 20-foot. Now, the site, or the plat was revised in February 21st of 2001. The only 2 lots that were affected by this were lot 167, 168. Also, there's some other lots, you'll see 3 lots up at the top that are not grayed out. They had some property line adjustments too, but they were nowhere close to this subject property. So lot 167, the subject property, upon the approval of this revision, the rear lot line was 69.26 feet, whereas previously with the original final plat, it was 78.36 feet. So you can see that that rear property line, or the width of the rear property has decreased. But if you look at lot 166, the rear property line there, which was 115, which is now 115, was originally 106, so it has increased. Then there was a second revision, and this one only affected these 2 properties, and that was on March 3rd, or April 3rd of 2002. In this one, lot 167, the rear property line is now 67.75, where before, on the previous revision, it was 69.26. And then the lot to the north of it, lot 166, its rear property line is 117, whereas before, with the previous revision, it was 115 feet. Again, the adjacent lot has increased in width, and the subject property lot has decreased. The attorney here, Mr. Duggan, had approached the adjacent property owners to see if there's any possibility of shifting that property line. As you can see here, there's only 28 feet, roughly 2.5 inches between the 2 houses. You have to have at least 30 feet if you have 15-foot setbacks on each side, so there is no wiggle room. So their only other option is to ask for the variance. So as far as county zoning goes, property, subject property is R40, everything around there is R40. The land use plan calls for single-family residential, and everything around it for single-family residential. There are no environmental constraints on the property. And if you have any questions, I'll be happy to answer them at this time. The applicant is here to present their case as well.
All right, questions for Mr. King? All right. Thank you, sir. Okay, this time, those who would like to present evidence supporting the variance may please come forward and be sworn. You swear the evidence you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. Thank you, sir. Mr. Duggan?
Good evening. May it please the board, chairman, council, vice chairman, staff. This is Vitaly Durkachev, and I'll be asking him some questions this evening. During my questions, of course, at any point in time you have a question, it generates a question, feel free to interrupt me. But I think we're going to be able to lay out for you reasons why this application should be granted. So, Mr. Vitaly, why don't you come on over here so the recording. Can you please state your name for the record?
Vitaly Durkachev.
Okay, and are you the owner of the home located at 8701 Man of War Drive?
Yes.
And when did you purchase the property?
May 28, 2013,
And you purchased the property with whom?
with my wife.
And that's Lucy?
That's my wife, Lucy.
And when you purchased the property, was there a home located on the property?
No.
And did you hire an attorney to close the sale of the property?
Yes.
Did you rely upon that attorney to do his due diligence in the sale of the home?
Yes, we did.
Did you rely on him to perform all necessary legal documents for the sale of the home?
Yes.
Did that attorney draft a deed for the property?
Yes, they did.
And as part of that drafting of the deed, I'd ask the board to kindly, you'll see under the exhibits, and does everybody have a copy?
Yes,
It's
we
going
do.
to be under exhibit A.
Yes.
And that, Mr. Durgachev, is that a copy of the deed for your property?
Yes, it is.
And as part of that deed, there's a reference in this deed to a plat recorded at Cabinet G, File 313. Is that right?
Yes.
Were you aware of the subsequent filings that were made regarding the plats of these properties?
Can you repeat the question? sir?
Sure. At the time that you took this property, were you aware of any other plats filed other than 313?
No.
And when you purchased this property, did you also purchase title insurance for the property?
Yes, we did.
Okay. And this was not part of the packet, if I could hand up if I could. Is this I can show you what we've marked as Exhibit A.
We want to mark it A1, otherwise we got two.
Oh, yes,
two
I'm
A's.
sorry.
Yeah, we'll
Mark
mark
it
it
A1.
A1. Thank you.
Thank you, sir. And this is,
Can I clarify one question?
yes, sir.
Did you say they built this house on the property, or the house was already there when they bought it?
No, they built the home.
Okay.
And this is a copy of the Schedule A, page 1 of the title insurance, is that correct?
Yes.
And under number 4, can you read that for the board?
The land referred in this policy is the state of North Carolina County Union is described as follows. Being all of Lot 167, Providence Downs, Phase 3B, Map 1, according to the plot, therefore recorded in the plot cabinet G at File 313 in the Office of the Register of Deed for Union County, North Carolina.
So at the time of your purchase, both the deed and the title insurance has a reference to plot or file 313, is that correct?
Yes.
Now,
And
was that, excuse me, a minute, was that the first plot, or is this the second plot of the plot, cabinet G of file 313?
313 is the first one.
That's the first plot, okay.
That's the first plot.
Okay.
So, at the time of the closing and at the time of the title insurance, were you made aware by your attorney or the title company that there were subsequent plats filed other than 313?
No.
And you decided to build a home on the property, is that right?
That's right.
And what was your role in that?
We acted as the owner builders, hold the permit as owner builders.
And did you hire an architect to perform drawings?
Yes,
And I got a copy here of these drawings. Are these the drawings that you had drafted by Building Graphics?
yes,
And they were architects?
yes,
Did they base these drawings off of the deed and the title policy?
yes,
So they based it off of file cabinet 313, is that right?
yes.
Did you rely upon the representations made by your attorney as well as the title company and the architect for the building of your home?
Yes, we did.
And did you cite the home based upon the deed and the title policy as well as the plans drafted by the architect?
Yes, we did.
And all of those referred to plat 313?
Yes.
Now, you completed the home in when?
We completed the home in 2015.
And did there come a point in time when you decided to sell the home?
3 years later, we decided to put it for sale.
And how far did you get in the sale?
We were under contract, and date was scheduled for closing.
Was a survey performed at that time?
It was performed a few weeks before.
And what was discovered as part of that survey?
It was discovered that our house is encroached 2 feet 6 inches over setback.
And that's under Exhibit F in the packet there. That's the survey that we have there. When you received that survey, what'd you do?
We went to Union County and consulted with our agent and talked to our neighbor.
Okay. Did you seek to see if you can revise those lines with your neighbor?
Yes, but at the same time, we had surveyor there, and surveyed assured us that we have no space to move the line or purchase the property from the neighbor.
When you discovered that, what was your plan at this point? Did you plan to go through with the sale of the property?
Well, the sale went, the buyers decided not to purchase the property.
As a result of that cancel of the purchase of the property, did you have to pay fees to the buyer for their due diligence?
Yes.
I have a question.
Yes, sir.
So, in all of this you're talking about, whose responsibility was it to correct this? As far as being, you're going by the first plat, and there's actually 2 more done, and that's what's got everything messed up. Whose responsibility was it to make sure that all of this information was accurate?
It'll be our argument that it was up to the attorney to do his title search, a due diligence search on the property. The title insurance company certainly should have done some checking or looking to see that they're insuring the right parcel with the right maps. Finally, the architect who did the drawings should have discovered these issues. It appears that everybody went off that old deed that at some point during the life of this property referenced at 313, and then over time, the 380 map and the other map was filed.
Okay, one more question then. Mr. King, would the third plat, would it not have superseded all of the other ones in the county information?
That's correct. The third plat would be superseding first 2.
But should it not have been placed in the file so it could have been picked up and know that that was the one they should have been operating off of? I guess that's my question. Was it the county's responsibility to make sure that this was the right plat? To make sure that it had superseded the other 2?
I think that, and again, I can only speak to speculation because I was not employed with the county at the time. But I can tell you this, with Providence down south, we have enough files that if that desk right there was hollow, it'd fill it up. It's typically what will happen is if somebody files a plat with the Register of Deeds, I'm not sure how they do the filing there, but typically Register of Deeds is the one that keeps up with when the lot lines change. Yes, if we have a subdivision and they do what we call a recombination, we typically will put the recombination into that subdivision file. But again, unless it's stapled to that final plat that was recorded, the original final plat, it can be easily overlooked, especially if you've got a couple of thousand documents you have to go through.
So that could easily happen today then?
It could. We are trying a whole lot better today. One thing that we do today in issuing permits that they didn't back in 2000, 2002, was when they would issue a building permit, on that building permit, it just said zoning, and you put a check mark in there. You know, does it comply with zoning? And what was that zoning? So in this case, they would have checked off, yeah, it'll comply, and it's R40 zoning. There's no conveyance of setback information, there's no conveyance of any easements or anything like that on that permit. So in respect to the developer, the contractor, it's up to them, it was up to them to gather all that information. In this case, I mean, you have a homeowner who is unfamiliar with this,
Right.
you know, so.
I guess my point being, I was just trying to convey the fact that it was a victim of circumstance is what it all boiled down to.
Yeah.
That's what it looks like.
Yes, sir.
Yeah, and may I also point out, back then, today, if somebody were to make an application for a single-family residence within a approved subdivision, we have a in-house policy says if you're showing a house, and this could be within 2 foot of that proposed or that required setback, we're going to require a foundation survey.
Okay,
They did not impose that back then.
Okay.
good, that's good. Thank you.
But the one that, basically the one that was hired to do the title search should have been the one responsible to go to the Register of Deeds or wherever they needed to go to make sure that there was not 3 drawn instead of 1.
That's correct.
Okay.
And if you look at the date of the deed and the date of the maps, the date of the deed that was drafted for my client in Exhibit A is after those other recorded maps. So a title search done on the property
Missed it.
should have picked that up. I'm not certain whether the title insurance company then just took the title opinion of the attorney, placed that title opinion, looked at it, and simply put it onto the title policy. We've made a claim to the title insurance, but we're still resolving that claim. We're trying to work that claim out. But that's
Okay.
kind of a victim of circumstance.
Okay.
Okay, one other question.
Yes, sir.
If this is approved and the 2.5 variance is approved on, will it stay just with this house or does it stay with the property? So if the house is torn down or it burned or has to be rebuilt, will it go back to original setbacks?
No, the variance will stay with, it runs with the property.
So it'll be from now on, then, rather than, if this house is torn down for some reason, tornado, whatever, he builds it back, he's still only gotta set the 12.5 feet then.
Well, that's why I'll recommend, you know, if there's a motion to grant the variance, that you use this survey as part of your motion to show that the variance is only for that little corner and not for the entire length of the property of 2 feet 5 inches. If you just make a motion saying we grant a variance at 2 feet 5 inches, that would reduce the whole setback along the whole property line.
That's my question, yeah.
And so I think you would want to make a motion to grant a variance, but only for that part of the house shown on this survey where it goes over the line. So it's actually a very You know, so if it, 100 years from now, it's really not much of a change.
Okay. So is that what you're asking for, or you're asking for the entire 2.5 feet?
No, we're just asking to bring the property into compliance. As
So
long
just-
as my client's able to sell the property with not having this cloud on title, and that's what it is, and that's why the other purchaser, prospective purchaser backed out, it was a cloud on title.
Okay,
So just that little corner would
that corner's
be,
all you're worried about. You want to be in compliance.
that's good, thank
All
you.
right, thank you.
Mr. Durkachev, had you known about the subsequent maps, would you have built the house in the same location as it is now?
No,
What would you have done?
we would just move it and because there's a place for it, so we would definitely move it. We would definitely make it compliant.
Okay. Who took those pictures, just so for the record?
I did,
Okay. And you went out there with the measuring tape?
yes,
So those are the pictures you generated that accurately represent the conditions that currently exist at the property?
yes,
You had the prospective purchaser back out of this application. Have you listed the house for sale at this point?
oh, no,
Is there a reason why at this point?
because it's not compliant with the zoning.
And is it your desire to bring the property in compliance with the zoning setbacks?
Yes,
And are you doing this so that it'll clear title going forward?
yes,
Is this home that you've built, is it out of characteristic for the rest of the neighborhood?
no,
Okay. There's an HOA in Provincetown,
yes,
and they govern construction
yes.
and garbage and everything else that's going on your property. Is there any kind of dangers or possible negative impact that it could have on anybody that would visit your property?
No,
This specific issue that we're dealing with today, that this is specific to your property, is that right?
yes,
And it all involves the reliance upon that prior filed application, is that right?
yes,
So, at the end of the day, you're requesting that this board approve your variance, is that right?
yes,
And you've asked and reached out to your neighbor to come in and testify tonight.
yes, I did.
Have you received any information from anybody that opposes this application?
No,
At this time, unless the board has any questions for Mr. Durkachev?
I'm good.
I'm good.
Well, I do have one.
Okay.
Yes, sir.
The neighbor,
Yes, sir.
so they are the 15 foot off.
Yes, sir.
yes,
So they're good.
Yes, sir.
It's just, okay.
And if I may call up Ms. Humbert to testify, she's the neighbor of the property?
Yeah, she'll need to be sworn.
Yes, sir. Thank you. Place your left hand on the Bible, raise your right.
You swear the evidence you give is the truth, the whole truth, and nothing but the truth, so help you God. All right, just please state your name.
Kathy Humbert.
Just speak to the mic, please.
Yes, please. if you could.
Kathy Humbert,
Ms. Humbert, where do you reside?
8705 Manor War.
And you'll reside next to Mr. and Mrs. Durkachev?
Yes,
And you were made aware of the setback issue on their property?
yes,
Do you have any opposition to the application?
not at all.
Okay. Is the house in compliance with the rest of the neighborhood or characteristics of the rest of the neighborhood?
Yes,
Is there any issue that you had yourself or your property for future use of your property? And if you had sold a portion of your property to try to bring this compliance, that would conflict with your setback, is that right?
exactly.
So you would support the application of Mr. and Mrs. Durkachev?
Any questions? All right, thank you. Any other witnesses?
No other witnesses for this matter?
Okay.
I would note that, this again, it was brought up as a circumstance issue. The deed has it, title insurance has it, architect gives drawings based on those plans. We'd ask this court, in the interest of justice, the fact that it would be considerable detriment to the property marketable title, as well as the cost to reconstruct or to tear down, that the board grant this application for a variance for Mr. and Mrs. Durkachev.
Thank you, sir.
Thank you.
All right, at this time, if there's anyone who would like to present evidence in opposition to the variance, please come forward. Seeing none, board, do you have any more questions we need to ask before we close the hearing? Hearing none, close the public hearing. This time, board, we have 5 findings of fact. Mr. Sturgis, would it be appropriate at this time for me to the applicant's findings of fact are very apropos, I believe. Can we just enter those in as findings of fact for us and just, I don't,
Where are you?
instead
are
of
you
going
looking
through
at the
each and every
letter?
one of them for, they're on page 3 and 4.
3 and 4.
I read them, they seem
You're
to,
talking about, oh, I see.
I
Yeah.
just think that would make more sense than us sitting here trying to,
Right, I don't think you need on these to vote on each individual
okay.
finding the fact like.
Can we just enter those in as our finding of fact if we vote on this thing?
Yeah,
Okay, and there was one issue, we want to clarify that it was not the entire length, it was just for the current
For the affected area.
affected area, so to clear that up. So if I have, at this time, if there's no discussion, we will call for a motion.
I make a motion to approve this variance on the exception that it only applies to the affected area of the property and not the entire property line.
Okay. All right,
And it's set forth in the survey?
That's set forth in the survey. And,
that,
what was that survey
Exhibit
number
one.
on that? 317?
well, I don't know, but we need to, what do we need to clarify which survey?
No,
Because there's so many of them.
There's only one survey, the others are plats.
Okay, the survey,
Plats.
okay.
Okay.
As per
Well,
the
then
survey.
plats, but
No,
the
no,
one
no.
we're
The survey.
going on,
You want the survey, right?
Right.
Yes, okay.
okay, okay.
So that's the motion. You got that? Motion and a second. Who's second?
I'll second.
Motion by Mr. Tilley, second by Mr. Davis. All those in favor say aye. Aye. Any opposed? All right, thank you, sir. Now, let me go on to number 2. All right, next item on the agenda is variance petition 2019-02, 9009 Man of War Drive, seeking relief from a 3 foot from required 15-foot side yard setback. I'll ask at this time, is there any conflict of interest on this case from the board? Hearing none. I guess the petition's complete. All right, I'll have a motion to hear this case.
Make a motion to hear the case.
Motion by Mr. Davis, I have a second.
I second.
Second by Ms. Stewart, all in favor say aye.
Aye.
Any opposed? Okay, Mr. King.
All right. The second variance request is also on Man of War Drive, also in Providence down south, located at 99 Man of War Drive. The owner and applicant are Richard and Denise Gordon, and they are here tonight. They're requesting a variance to Table 5-2, lot and building regulations. The applicants are seeking relief of 3 feet from the required 15-foot side yard setback. The house was built in around 2002. I know that it's had multiple ownerships. I don't know how many. I'll let the applicant speak to that. This is the survey right here, taken on June 22nd of 2019. In this case, which is a little bit different than the last case, the whole side portion of the house is encroaching into that 15-foot setback by 3 feet. So the subject property is lot 185. This is the original plat map, which was recorded on November 13th of 2001. Lot 185, the front property line is 120 linear foot in width. However, lot 186, their front property line, or the width of the property, is 103.37 foot at the front property line. Again, the setbacks are 40 in the front, 50 in the rear, 15 on the sides, and 20 for a corner lot or a corner street, per the recorded final plat. This lot line was revised in 3/8/2002. To the best of my knowledge, it's only between the adjustments are only between lots 185 and 186. I didn't see any differences there. However, in this case, they did not black out unaffected lots. Here, at this revision, lot 185, the subject property, the property line, or the property width of the front property line is 114.46 feet, whereas previously it was 120 foot. And lot 186, the adjacent property to the north, the property width there is 110 feet, .3 at the front property line, where opposed to the original plat filed and approved and recorded, where it was 103.37 feet. Again, property here is R40. A portion of this property is in Marvin's jurisdiction, zoned R40 with them as well. And to clarify what portion is in Marvin's jurisdiction, this slide right here shows you that it's to the rear of the property. Our land use plan calls for it to be all single-family residential. There are no environmental constraints on the property. And with that, ends my presentation. If you have any questions of me, I'd be happy to answer them at this time.
I do have a question,
Okay?
not necessarily relative to this exact case. Are there more of these out here?
Probably so.
Any way for us to find out about them, or are we just going to have to wait till this happens every time?
If we go survey every property in Providence, Downs, and therefore Union County, we'll probably find a whole lot of them, but we ain't got the resources or manpower to do that.
So when somebody goes to sell a piece of property, they're gonna come see us.
Yep. Same thing with the.
And it's gonna
Stinson
cost them all
Harness
that
Road.
money to do it.
Yeah, remember, well, same
And
thing.
Mr. Duggan's gonna take a lot of money as attorney, because, oh my goodness, okay.
Mr. King, got a question.
Yes, sir.
Would it be, in accordance with what we just did, rather than move the whole setback 3 feet, just do it in accordance with what's been affected here?
That's perfectly fine
Okay.
to make
So it
that.
would be
Or the whole- but
affected
the whole-
along the whole edge of the house.
The whole line, is
The whole-
because the whole house is on the line, unfortunately,
Right.
here, not the
So
corner.
therefore, what that would do is if they wanted to do an addition to the house, the addition would have to comply
Comply.
with the 15-foot
Gotcha.
setback.
That's correct.
Good.
So that way we wouldn't be doing the whole 3 feet of the whole length of
That's
the property.
correct, yeah.
Just the part that's affected again.
That's correct, yeah.
All right,
Will that be accepted?
Yes, sir.
all right, thank you. Anything, Mr. King? Thank you.
I'm good.
All right, Mr. Duggan.
May it please the board, Chris Duggan on behalf of the Gordons. I have 3 witnesses today. I think I can swear all 3 in.
Let's do that. Let's get them all sworn in. It's their first time, at once, and we'll be good to go.
Place your left hands on the Bible and raise your right.
You swear the evidence you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. All right, Mr. Duggan.
All right. I'm going to ask for Ms. Louise Casella. Can you please state your name for the record?
Louise Casella,
And Ms. Casella, where do you currently reside?
706 Deer Cross Lane in Waxhaw, North Carolina.
And were you the property owner at the time of the application?
Yes, I was.
And are you currently the property owner?
No, I'm not.
And when did you sell the property?
July 30th or 31st, 2019.
Okay. So at the time of filing the application, you represented that you were the owner, but that has changed, is that right?
That's correct.
Have you assigned any and all rights to the current owners?
I did.
And why don't you tell us a little bit about when did you purchase this property?
August of 2013
And when you purchased this property, who did you purchase it with?
with my ex-husband.
And when you purchased this property, were you the first owners of the
Oh,
property?
and I'm sorry, he wasn't my ex then. He was my husband then. At the time.
And when you purchased the property, were you the first owners of the home?
No, we were not.
When was the home built?
Around 2002.
Okay, how many owners were between 2002 and you?
I'm not sure. I know it's at least more than two.
Okay. When you purchased the home, were you involved in the purchase of the property?
I was not. My ex handled that.
Okay. Did he handle all the paperwork and documents?
He did.
And did you, were you made aware of any issues or problems with the purchase?
No, I was not.
At the time of the purchase of the home was not in compliance with the setbacks, is that correct?
Apparently so, yes.
And there came a time when you became the sole owner of the property, is that right?
Yes.
And when was that?
That was during the divorce. I was awarded the property as part of the agreement.
And you have some children?
I do. I have 3 children.
And when you were awarded the house as part of the divorce proceedings, was there any title search done on the property?
No, there was not.
Any surveys done?
No.
When did you first become aware of an issue with the property?
A few weeks before our scheduled closing, when the Gordons hired a surveyor and did a survey, and it came up on that survey.
Was this the first time you were aware of that issue?
Yes.
And when you discovered that, what did you do?
I got really nervous. I didn't know what to do. I talked to my realtor. I reached out to the Gordons. I reached out to the planning department. I reached out to Mr. Duggan. I didn't know what my options were. None of them seemed good.
And why were you trying to sell the property?
It was just a smart decision to downsize for the benefit of my family, for me and my kids.
So you were planning on going to another home, is that right?
That's correct.
And was that purchase of that home, was that conditioned upon the sale of this home?
Yes, it was.
And the sellers of that other home that you were gonna go to, was that also a conditional sale?
It was, and it produced a domino effect. So it impacted several families.
When you first became aware of it, did you approach your neighbor about?
I did. I spoke to the Dickinsons, and I asked them about possibly doing some kind of recombination plat. And they were not able to do that because they had plans that would make, for the future, for their property, that would bring them out of compliance if they did that.
So you sought out trying to readjust the lines of bringing you into compliance?
I did.
And you were prepared to purchase portions?
I was.
You were not the builder of the home?
No.
You had nothing to do with the construction of the home?
No.
The siting of the home?
No.
So once you discovered this, your concerns were about moving forward with the sale, is that right?
That's right.
And you were concerned about children and getting them into the new house. Why don't you tell the board a little bit about that?
Well, my children had been through a lot through the divorce, and they really didn't want to move. It was very stressful for them, and they definitely wanted to be settled into the new home before school started. My oldest went off to college, and he also wanted to be settled somewhat before he left home. So it was very, I really wanted to move forward to get my kids settled and ready for the school year.
What was the effect of the non-compliance on your home?
As I understand it, it affects its marketability, and as I heard just previously, having, not being able to pass clean title would dissuade a buyer from coming.
And what would you have to do to bring the home into compliance?
I'd have to tear it down. And that's, it affects the whole length of the house. That's 2 floors. That's the master bedroom, master bath, closet, second floor bedroom, and another bathroom upstairs.
And what was decided at that point?
We decided to move forward we knew that we had an option to seek a variance, and that's what we did.
An agreement was made with the Gordons to seek this variance?
Yes, it was.
And do you support the application of?
Absolutely.
If you have any questions?
Any questions? No.
Thank you.
Thank you.
Mr. Wood? You please state your name for the record?
Denise Gordon.
And are you currently the owners of the property located at 9009 Man of War Drive?
Yes.
All right. And you own the property with whom?
My husband, Richard Gordon.
He's not here tonight, is that right?
He is not.
He had some surgery on Thursday?
Yes, yes.
Too much hockey?
Too much hockey,
Okay.
definitely.
All right.
So I'm the lucky winner.
Hope he's doing well.
He's not doing well, to be honest.
Sorry to hear
As he
that.
was trying to claw his way out of a chair to get here, I'm like, at the point you can't even get out of a chair, I don't think they want you to come.
All right. And you heard Ms. Casella's testimony here today?
Yes,
And do you agree with that testimony that you went forward with the sale of the property, understanding that there was noncompliance?
yes.
And why did you decide, you and your husband decide to go ahead and go forward with the sale of the property, or the purchase of the property?
Well, it really stemmed from the domino effect that there were 3 or 4 contingent sales in front of us, and we were the starting point. So if we didn't close, all of those other families couldn't move forward.
And you did some research as to what it would take to go through with the variance?
Yes, a grueling amount of research.
Okay. And you understood the risk, that the variance could not possibly be granted, is that right?
Sure.
But you went forward with the sale anyways in order to keep those dominoes standing upright?
Mhm.
Is that, you gotta say yes. for me,
Yes.
Sorry.
Yes.
Just needs to pick it up. Other than the survey that you were, or strike that, at the time of, shortly before the closing, you had the survey done of the property?
Yes,
And that's when the issue with the setback was discovered?
yes.
Was it, did anybody provide you information about the issues with the setback prior to the survey?
No,
Okay, so until the survey was done, you had no notice of that issue?
no,
Are you aware of anybody objecting to your application?
no.
Did you approach the neighboring property about possibly trying to readjust lines?
Yes, we did.
And what happened?
Mr. Dickinson said he had some plans for his property that could be years in the making, but some improvements that if we moved the property line, that would put him in a place of hardship and would make some setback issues for him.
Is there anything about the current construction of the home that poses a danger or threat to the community?
No,
Is there anything about the current construction of the home that puts it out of the general characteristics of the neighborhood?
no,
Are you in agreement that you would, if approved by this board, granting the variance, that you would accept that the variance only apply to the portion of the house that's not in compliance?
absolutely.
And you understand that you cannot build within the 15-foot setback in any portion of the property, is that right?
Correct.
Okay. And you're requesting that this board grant your petition, is that correct?
Yes,
Any questions?
Any questions?
Now, I commend you on your faith in this board that would be fair and honest with you, and
Thanks.
going ahead and having the whole domino effect rather than destroying it.
thank you.
Thanks, sir.
Then
Thanks, sir.
our last witness.
I don't think she actually knew who the members were, so.
The board itself
And she has faith in her government.
and our government system.
Can you please state your name for the record?
Gary Dickinson,
And Mr. Dickinson, where do you reside?
9013 Manamore.
And is that next door to the Gordon's property?
It is.
And were you approached by the Gordons regarding a property line adjustment? or-
We were.
And what was discussed?
They mentioned that, that there was a setback issue, and it's on the side of our property where we have another structure that we're going to put up. If we granted that, it falls far enough back, that structure would have been out of setback, so we couldn't comply.
Okay. So you have plans to build on your property that would have been impacted if you sold?
We do.
Okay. Are you aware of any opposition to the request?
None whatsoever. It's been there for a long time.
All right. How long have you lived there?
Since 2000, time's flying, 2013, I think.
Okay. Have you ever had any problems with the location of the house next to your property?
None.
Do you support this application?
Absolutely.
Other questions I have?
Any questions? Thank you, sir.
No more witnesses? I will just say that this is unique to this property based on the circumstances and different than the other property. I understand that they're both on Man of War, It appears that the developer had a habit of filing subsequent plats on a regular basis. My hope is that this is not something that's going to continue to develop within the neighborhood, but of course we'll bring to the board's attention. One other thing I'd like to bring up is that we are reserving our rights under the North Carolina General Statutes 1-49 and 1-51, which is the statute of limitations defense. There is new statute of limitations legislation that came out that's effective in October of 2018, one of which says that the county cannot bring an enforcement action within 7 years of the violation if it's readily apparent and visible from the street. How they can justify it with their eyes, that's an argument for a court, but we'll reserve those rights under 49 and 51. Thank you.
We'll note that, I'm not sure that's of significance to this board, but
Understand.
what you said's in the record, but it's not relevant for their decision.
Thank you, sir.
All right. Anyone here who would like to speak in opposition of this variance, please come forward. Seeing none, this time, does the board have any other questions we need to ask before we close the hearing? Hearing none, close the public hearing. Again, with this case, I believe the applicant did a fine job of finding the facts. So I would note that and ask the board for a motion.
Make a motion that variance be granted with the indication or acceptance, however you want to word it, that just the property affected will be granted the variance.
I'll second it.
Motion by Mr. Davis, second by Mr. Tilley. Any other discussion? All in favor say aye. Aye. Any opposed? Thank you all.
Thank you.
This time, there's nothing else to come before the board.
I will tell you
I
what.
will ask for a motion to adjourn.
Make motion to adjourn.
Motion by Mr. Davis, second.
A second.
Second by Ms. Stewart. All in favor say aye. Aye. Opposed?
Oh, Ms. Anderson. Who's Ms. Anderson? Jennifer Anderson. I'm sure.
I'm sorry, Ms. Anderson.
You put that on one of my packets, I think.